Good morning. On the 17th of April 2021, I set out to do a video which pretty much addressed a number of issues that we're having and are having or is having in the Supreme Court of Jamaica, and a number of things that we think must be dealt with. If it's not, it is eventually going to lead to a serious collapse of the court and a failed state in the island of Jamaica. We believe that to be true. That's our assessment, because no judicial process can continue where corruption goes unabated. And what we found in the Jamaican Supreme Court, I have proven without a doubt that there exist certain individuals that are operating within the courts that continue to operate on the basis that they are above the law and above the rules of the court. And so they've chosen a path that's going to be leading to other justices being looked upon as being corrupt and dirty in general. And we know that's not the case. So one of the disclaimers that we'd like to make this morning is that we know that there are good, decent individuals who've decided to become judges in our judicial process with the intent to deliver objective and fair and just resolutions to matters that need to be in front of the court. I'd also like to remind anybody that gets this video or an opportunity to hear what I have to say is that our judicial system and judicial systems globally were put in place so that we could bring around resolutions to issues where a third party, an objective third party, a party with nothing in the game, to make a decision where all the litigants or parties opposing each other in any particular issue will believe and feel that they have been treated justly, and that any resolution that comes out of the discussions within the judicial system, that it was done in such a way that there can be no misconception or conceptions that the ruling was biased or deliberately fraudulent against that other party that it's not favorable to. And that we've agreed to subject ourselves as citizens within a particular state to the courts, because we want to ensure that we don't have to resort to barbaric means of settling issues, and therefore helping to build and maintain civil society. We want to live in a peaceful community amongst humanity, so that we can advance humanity and not tear it down. It has become necessary, however, to deal with this video of matters that we deem necessary, having to do with two specific cases in the Supreme Court and what we believe will be a breakdown of the system. So the disclaimer is again, disclaimer, and is that we need the support of everybody that's subject to courts globally, and those parties who work within the system, including judges, administrators, clerks, intake clerks, to become vigilant and become a part of the solution and not maintain the problem, and to ensure that you don't look at this criticism that's going to occur during this video to believe that this is an attack on you personally, unless of course you're part of the problem, you're part of the corruption and the civil crimes that go on within the judiciary. Now, we know it happens because the statistics prove it, and globally, well, I believe I'm not going to go globally, I don't have those statistics, but I know I've read statistics where corruption in the judiciary in Jamaica is in excess of 40%, and sometimes as much as 60%. But whether those stats are true or not, the fact is, even if we had 2% of the judiciary being corrupt, that's a significant number. When we start going over 20% or 40%, as much as 60%, then we know we're definitely in trouble. And our experience is that the level of corruption period in any organization is going to lead eventually to a collapse of the organization once the corruption is discovered and exposed, and that's what we're here about. Now in 2010, we were served with a summons from the Supreme Court by Capital One NA. Capital One is the United States of America's 10th largest bank. It is a significant player in the financial sector and the banking sector, and it has, affiliate organizations that range from loans on cars to credit cards. So we got a summons served on us from Capital One, alleging that they had an interest in property that we had bought from a USS, individual that was deceased. We purchased it from the estate through the rightfully appointed executor, David Rubin. So when we acquired that property, one of our objectives was to develop the property, and we got approved several mega real estate developments, over 10 million square feet, in fact 14 million square feet when finally done, of mixed use, commercial and residential real estate asset capital. And that was the beachhead of our projects. And we had several satellite projects that were stretched across the island, and we were also looking at projects in Nicaragua and Haiti, in the US as well. So the primary project and objective was to develop that property into our lead project that would be available for investors and partners from Jamaica and across the planet. And we did have partners from across the planet. So in June of 2010, we got served, and we ended up in court, on the Supreme Court. I don't remember the exact dates, but when we got there, we were in front of a Justice Beckford, Miss Justice Beckford. And of course, we didn't really take the matter seriously at that time, because what was being sued on was not consistent with what reality or that they had standing to have filed the suit. So when we went to court, we were alarmed when the judge ruled in favor of Capital One. After that ruling, we decided to appeal, obviously, which we did, and the appeals court ruled in our favor. So they didn't have standing or claim, and that the matter should have been thrown out, but for the fact that our attorney didn't ask for it to be thrown out, and the court was not in a position to do so, so it was remanded to the Supreme Court, where we expected it to be thrown out. And we filed the necessary applications for that to happen. That was in June, I believe, of 2010. So in July of 2010, or thereabouts, we got a notice that John Graham had taken over the matter and that he filed and received an injunction. Shockingly enough, we couldn't understand why and how, because the appeals court had already ruled that this case shouldn't be there, but some judge gave him an injunction. I think it was Justice V. Harris gave an injunction, and it was to last 28 days. So when we got notice and that the matter was coming for hearing in 28 days, we showed up in court, of course. We had already filed applications for the claim to be dismissed, and so we ended up in front of a Justice Mangatal, I think. And when we showed up, Lady came there with one piece of attitude. So we had an attorney, Johnson, at the time, who we paid a significant amount of money to represent us and to remind the judge that the matter was already ruled on pretty much by the appeals court, and that we're only there for the orders for it to be officially dismissed. And in addition, I instructed the attorney to let the judge know that none of the parties to the claim or the defendants or the companies involved were domiciled in the island of Jamaica or had any assets or anything here, and that the matter should be dismissed. Justice Manuel cussed out our attorney and told him he should know better than take any such instructions from a client. We didn't see anything wrong with it, we don't know what was wrong with it, but the attorney pretty much just shut down at that point and said nothing else. So Justice Mangatal looked over to John Graham and said, "Oh, you have an injunction, right? Well, I'm just going to continue it." So my attorney sat there. Since we're a representative, he said, "You know what, let me not say anything much." So I sat there. So she extended the injunction. Didn't dismiss the matter even though the application was there. And John Graham made no application for the injunction to be continued, or not in front of us. We don't know if anything took place behind the scenes, but she did do that. So subsequently, we exited the chamber, and our attorney Johnson said to us, "Oh, Anthony, that judge not like you." Of course, my reaction was, what does that have to do anything? I don't give a hoot if the judge liked me or not. You needed to do your job. You didn't do anything, you sat there. So he pretty much left and billed us with a billing which included a $15,000 bill for him to file a notice with the court that he was representing us. He just found ways to hold on to our money without giving us any kind of representation. So after that point, we kept going back and forth to court. The files would disappear and reappear at its own convenience, apparently. And then we ended up in front of a Justice Evan Brown, who no files were there, but the judge decided he was going to extend the injunction again, even though we pointed out to the judge that we didn't, there was no reason for the injunction, and it was holding up projects that were approved, mega projects approved with funding, and we were losing money, and there was no basis in law for the injunction. And he just simply again decided, well, he couldn't make any rulings in the matter because the files were missing, wasn't in front of him, and therefore he could make a ruling. But yet he went on and adjourned the matter and continued the injunction. So between that point, which was probably 2012, 2013, the matter dragged on and on until we finally wrote several letters to the then Chief Justice, Mrs. McCullough, who said she would recreate the files and put them under security, which we were told she did. And eventually the files disappeared again, kept disappearing. So we wrote again and said enough is enough. The appeals court had already ruled in the matter, and we needed to move on with our business and our lives. And we were losing millions and millions of dollars on a daily basis. And so Justice McCallum appointed a judge, Mrs. Beswick, to take the matter, review it, and make a final determination on the case. So in May of 2015, the 29th of May 2015, Justice Beswick called us to court and handed down her judgment, where she said she dismissed the claim. She removed she dismissed the claim. And John Graham raised hell in that hearing and said he did not understand what the judge was saying. So I asked the court permission to appeal in the event that the court complied with what John Graham was asking and allowed the matter to continue. But Justice Beswick dismissed it nonetheless and said instead of filing an appeal, she was asking me to hold on. She was going to take the time to review the application again, or the case, and would get back. So between May 29th, 2015 and May 23rd, 2015, we waited, and on the 23rd of December 2015, Justice Beswick made a clarification of her judgment. And the clarification merely said that John Graham, representing Capital One, that she ruled that the case was dismissed. Yeah, that the case was dismissed. That she was removing the injunction, and that Capital One was liable for payment of the damages as stipulated in the undertaking for damages given to the Supreme Court when they applied for the injunction. Now, the undertaking for payment of all damages stated clearly that the undertaking, Capital One, would be responsible for making payment for all damages resulting from the injunction. And it did state that damages affecting the defendants. Now, the way the structure of the undertaking was written, it was any damage resulting from the injunction. That means anybody that got damaged as a result of the injunction was entitled to payment of damages. So when Justice Beswick made her ruling, the undertaking, she specifically stated that the undertaking meant that Capital One was liable to pay all the damages. And she went on to say that the only defendant that was left in the matter, Business Ventures and Solutions, who I represented, would be responsible for proving the damages. So whatever damages was proven, that was the damage or the amount Capital One was liable to pay. We did that. And so instead of us merely calculating damages, we asked the court, the Supreme Court, to appoint two expert witnesses, an accounting firm or a person, and a technical person, an architect, to determine the damages. So the court appointed those expert witnesses, and when they submitted their reports, preliminary reports, it wasn't a totality of the damages. It wasn't a totality of the damages. The damages were substantial, amounting to almost 30 billion US dollars. Because as I said earlier, we were engaged in several mega real estate developments across the island, in the US, as well as looking at developments in Haiti and Nicaragua. And so they, based on the preliminary numbers and some proprietary products that we were producing for the projects, we would have come in with the capital itself of over almost 30 billion US dollars. So using those numbers, we asked the court, which were the assessment was admitted into the court's records, and the accountants certified and the expert witnesses certified those reports. So at that point, we asked the court to set up time for a final order on damages and a final assessment of the damages, where the totality of the damages would be given. After that point, John Graham, at every hearing we had on the matter, would enter the chamber and tell the judge that the previous judge had said there was to be a hearing on whether we were deserving of the damages or not, or entitled to damages or not. And of course, no judge made those orders. But eventually what happened in my absence, Justice Justice Batts abandoned the date set for assessment of damages and proceeded to make an order that there was to be a hearing on whether we were entitled to damages or not. Again, after that, the files disappeared, and the matter on damages didn't come in front of the court until, again, 2018. And in 2018, we went in front of a Justice G. Brown, the Honorable Justice G. Brown, who ruled that not only were we entitled to damages, but Capital One, and his precise words were, Capital One had given the Supreme Court, the Jamaica Supreme Court, an undertaking for payment of all damages, and that undertaking for payment of all damages must be honored. And of course, at that hearing, Capital One also attempted to say to the court that I couldn't represent Business Ventures and Solutions because I was no longer the owner of Business Ventures and Solutions, Inc. Of course, all of those statements were fraudulent, but based on the fact that we anticipated that Capital One and John Graham had conspired and had filed papers in the United States courts that I owed Capital One money, which the courts already ruled I didn't, conspired and filed papers in a bankruptcy court in the US that I owed Capital One money, and therefore the court, in claiming they were working to settle the debt, sold my 100% interest in Business Ventures and Solutions into Capital One. Of course, all of that was fraudulent, because not only did I not owe any money to Capital One, but the appeals court had already ruled in 2012 that I didn't. And Justice Beswick had also ruled in 2015 that I didn't. Yet, on affidavit evidence filed in the US court and supported by actions of John Graham, they filed that in the bankruptcy court, which is a federal crime, of up to 5 years in prison. So, and in a bankruptcy proceedings, there is no statute of limitation on fraud. So, as it stands, John Graham and his co-conspirators, Capital One, filed in a US court that fraudulent documents. But nonetheless, the trustee was also seemingly working for Capital One, claimed they sold my interest. Now, technically, they advertised and claimed they sold it, but little did they know as well that I had already, from 2011, given all my interest to other parties. I will remain the director of the company, which still allowed me to represent the company. And on reading all of that and reading the fraud and what took place, Justice G. Brown, in the same hearing, I think in 16th of May 2018, ruled that I was appointed or recognized by the court as representing business ventures and solutions. Thinking that the judge also set the matter for hearing on interim payments, because in the Supreme Court or in Jamaica, the rules of the court are, if the damages are substantial, we can ask for interim payments, which we did. So that was set for July 4th, 2018. However, when we went, the issue of substitution of parties came into play, because since Capital One had attempted at fraud of claiming that they had acquired 100% interest, I proceeded to file papers in the court identifying the persons who actually were equity holders in the company, as well as entitled to damages resulting from the injunction, and had them file necessary letters to the court and the registrar, which was required by the rules. Excuse me. So when we came up for hearing that 4th of July 2018, the justice who appeared said, based on the fact that there were parties who had to be substituted, and under the rules of the court, there is no question whether they must be substituted or not. The rules say they must be. And since it's our property and our damage, and I was the party responsible, there was really no party who could object to this interest being passed on to other parties. Nonetheless, when we appeared, the files weren't there, and the justice decided she wasn't going to adjourn the matter until the 25th of November 2018, so that the matter could be heard. Now, that was done because the assessment of damage was set by Justice G. Brown for the 29th and 30th of January 2019. So the justice decided the substitution should be done prior to that, and that made sense. So she said she wanted it done before the hearing on damages. So she set it for the 25th of November. November 2018. When we showed up for hearing on the 25th of November, Justice Kirk Andrews showed up. And one of the first things he said was he couldn't make any orders on the matter of substitution, because he had just gotten the files of Friday. This was, I think, Monday or Tuesday. He had gotten the files of Friday prior to us coming to case management on the 25th. And he needed more time. I said to the judge, listen, the reason the matter was set for the 25th was because we were set to appear for final orders on damages on the 29th and the 30th of January. And the justice decided it had to be done prior to, and we have no issues with that. But since it was a matter of our property, and the persons who were being substituted, their property, and the rules of the court said they must be substituted on letter to the registrar, then all we needed was him to make such an order. And in reality, Capital One, the judgment debtor, didn't have any basis in fact or law to object to it. They can't tell us where or who to give our property to. And the judge went on to say he wouldn't do it. And so he proceeded not to set the matter for an earlier date before January 29th or 30th. He set the matter for, I think, March of 2019, several months after we were scheduled for assessment of damages. We nonetheless showed up on the 29th of January for assessment of damages. And while we were there waiting, and the time did come for the judge to appear, here came Justice B. Morrison. Justice B. Morrison. Not to be confused with Justice Morris from the Appeals Court, granted. It's a different justice. So Justice B. Morrison of the Appeals at the Supreme Court appeared gratefully, almost hopping across the room, nothing in hand, and no papers on it, saying, "Oh well, I don't have to hear anything on damages today because the damaged parties withdrew, filed a notice of withdrawal for the damages the night before." So on the 27th, the 28th, somebody went and filed a so-called notice that we were withdrawing our right to damages. So I told the judge, we made no such application. Why would we be here? Why would we have representatives, and why would all the parties, at least some of the parties, and there were multiple parties who were damaged, be here? Furthermore, the application was made only in the name of one party, Business Ventures and Solutions, which was not the major damaged party. And in the gist of all of that, the judge said he didn't want to hear nothing from us. And regardless of how we pointed out that we didn't retain anybody, there was a young lady in the room claiming she represented the party. Well, she filed a notice, and he allowed her to participate. In fact, he only took arguments from her and from John Graham, and then said, well, he wasn't going to hear anything from us because we had an attorney. So I told the judge, there are multiple parties, and I have represented myself from earlier in the game, and I appeared pro se. It seemed like the judge didn't know what pro se meant, so I explained. I said I appear pro se, meaning I'm representing and have represented myself. And I said, furthermore, Justice G. Brown had formally appointed me as being able to represent Business Ventures and Solutions Inc. So I'm not sure who this lady is, but we didn't retain her to do anything on any behalf, and in any event should have to come through me, because I'm the only court appointed individual there to represent Business Ventures. Come to find out that young lady, Alex C. Robbins of Miles Fletcher and Garden, didn't even file a notice in the court that she was appointed. The judge nonetheless said he wasn't gonna hear anything from us. Pretty much trashed me and stated that I was being disrespectful because I insisted on saying to the judge in a polite way, I wasn't rude, I wasn't boisterous, I wasn't loud, that I did not retain this woman or this young lady, and that obviously somebody filed a notice that we knew nothing about. He said I was being disrespectful, he wasn't going to hear anything else, so he moved on to other matters. We left. Now, that's the kind of thing we're talking about. That's the kind of corruption we're talking about. And we didn't think this was by accident. It couldn't have been. First of all, somebody filed a fraudulent notice of withdrawal the night before the hearing. We knew nothing about it. We told the judge. The judge said, no, I hear anything from us. And come to find out, Justice B. Morrison was the same judge who appointed Capital One administrator for an estate that didn't exist. This was done in 2013. So it can't be a coincidence that, no, this is the same Justice Morris who appointed Capital One as administrator for an estate, a New York estate, by the way, that doesn't exist, so that they could appear in court as being a legitimate representative after the appeals court said they weren't. And after Justice Beswick had ruled in 2015 that they had no standing, this was the same judge now who appeared at the hearing for assessment of damages and pretty much just abandoned the hearing in support of the same party who had filed fraudulent notices to the court. I'll continue in my other video. Thank you.